All right, welcome everyone. I see we've got folks coming into the webinar, so we'll get started here uh, with Chuck's presentation this morning. First, just want to welcome everyone back to the Arvada Employment Law webinar series. My name is Daniel Riley. I'm with Arvada Economic Development Association, and we have had the absolute pleasure of partnering with the Arvada Chamber to bring Chuck Pasaglia from Employment Law Solutions to our business community to provide a lot of very timely and valuable insight on what's going on in the employment law and human resources world. And we were fortunate to have Chuck with us last week as well, where he covered some very interesting and helpful topics around specifically COVID-19 related workplace issues in employment law, including things like vaccinations. And so we did record that. Presentation is available on the Chamber's website, so we encourage you to check that out if you were not here last week. This week, Chuck's going to take it in a more traditional direction as far as all of the updates coming out with new legislation this year. And we love Chuck. He's been partnering with us, providing this type of insight and education to our business community for many years. And so we're thrilled that through our partnership with the Chamber, we can provide that opportunity to even more businesses. And I believe this recording or this presentation will be recorded as well for future use to rewatch or distribute. And so I'd like to introduce our guest of honor, Chuck Pasaglia with Employment Law Solutions. Again, he's been such a great resource for Arvada businesses, including the city of Arvada. All of our HR folks are always working with Chuck to make sure we're completely up to date on everything that's really relevant and necessary from a legal perspective in our workplace. So we hope that you find as much value in what Chuck has to say today. And we are glad that Chuck has a way to kind of lighten the mood too around some very challenging and difficult subject matter. So we appreciate that that talent he brings to the conversation as well. So without further ado, I'll go ahead and turn it over to you, Chuck, to take away your presentation.
All right, Daniel, thanks so much. And I once again appreciate the opportunity to talk to Arvada businesses. Really appreciate the Arvada Chamber and the Arvada Economic Development Association giving me the opportunity to do the program. Last week, we had a lively discussion about whether or not to mandate the COVID-19 vaccine. This discussion is going to be dizzying this week. We're going to talk a little bit about the issue of, hopefully I can now share my screen and are we good then, Daniel, or is that?
Yeah, I can see the screen share. It looks like it's
okay.
Ready to
Perfect.
go.
Yeah, thank you, Ryan, for us for doing this as well on the tech side. So we're going to have a dizzying conversation talking about a few things that are already in play for Colorado businesses. But I have to give a disclaimer, and Daniel mentioned this really in the introduction. The current legislative session in the Colorado legislature is a lively session, and there are a number of employment-related bills currently working their way through the legislature. Many of those bills are likely to become law. That is for another session. What I'd like to focus in on in this session are some things that are already on the table for employers to consider. And some of these employers should be presently engaging their organizations to try to meet these expectations. As with the last session, I try to monitor the chat through the Zoom. If you have any questions, I'm going to also leave time at the end of our session to answer any questions that I don't get to. But for those of you that are familiar with Zoom, please consider sending the question in the Q&A or simply using the chat function, and I'll try to get to those as we go through this. Also on our end, people with the Arvada Chamber, Ryan, Sam, Cami, Daniel on the Economic Development Association. If I miss a question or a chat, if you wouldn't mind helping me and jumping in, I'd greatly appreciate it as well. So let's talk a little bit about how the world has changed considerably, and a lot of these are related to COVID. So I mentioned relatively quickly, and I'm not going to talk about every one of these things in great detail, but I want to talk about it from the perspective of what I think businesses need to know. Most people are well aware that the COVID unemployment benefits have been continued through September 6th of 2021. What do I mean by that? The opportunity under the Pandemic Unemployment Assistance provision for self-employed workers, gig workers to obtain unemployment benefits, and then the extension of $300 per week in federal pandemic unemployment compensation into September. Why do I mention that? Well, not only can people potentially continue to obtain unemployment benefits, but that also is a consideration for businesses. And I would caution you, if someone says they are reluctant to come back, we need to formulate a plan as an organization of how to address that. As more and more employers are going back to good work, many people feel much more comfortable having employees return to the workplace, or customers or patrons return to our workplaces. I would caution you that you might get resistance from people who are reluctant to come back because of safety concerns or their family constraints. And so they may be able to continue to receive unemployment benefits, but you may also have to consider what will be the consequence to the employee if they fail to return. Why do I say all of this? Because I attended a session earlier this month about the widespread fraudulent claims and identity theft associated with COVID unemployment. I was shocked to learn that more than 1.2 million fraudulent claims have been filed in Colorado associated with unemployment benefits. So I did want to remind employers, and again, this is a wide-ranging session, that according to the state of Colorado, if you suspect that someone is obtaining unemployment benefits through fraud or has stolen one of your employees' identity, you should report that immediately to the state of Colorado using an employer reporting form. It's available at this website. If an employee comes to you and says they believe there has been fraud, for example, they've received a benefit card, we use a Relia card in which unemployment benefits may be obtained, much like a debit card. If they've received one in the mail and did not file an unemployment claim, then they should file an unemployment identity theft for individuals form with the state. They should also deactivate that card if they didn't apply for it. They should also certainly check the consumer credit bureaus to determine whether their identity has been stolen, and perhaps purchases or other matters have been engaged on their credit. And then, of course, whatever they have, including the Relia card that's used, they should maintain records of what they've done to try to protect their own identity. So that's a sidelight issue I wanted to talk about. Let's go into the first big law that I want to talk about for employers. This is a big deal. I'm sure you've heard about it. We talked about it in years past because there was a 2-year window for employers to ramp up to this particular responsibility. So as of January 1st of this year, all employers in Colorado, that is everyone likely listening to this program right now, should be complying with Colorado's Equal Pay for Equal Work Act. That law, which makes it very clear, it protects people on the basis of their gender in their compensation. You cannot pay different wage rates to different people based on gender, or, by the way, gender identity, or any combination of gender and any other protected status for doing substantially similar work. What do they mean by that? That means a composite of skill, effort, and responsibility. This is a big deal because not only do you have to pay people the same wage rate, but you can't pay them differently unless the wage differential falls into one of these 6 categories. And this is important. We can pay people differently based on their length of service, merit, the quality of production or quantity of production. If you produce more widgets, you could make more money. Geographic location, it may be more expensive to live in the Denver metro area than in more rural areas. And of course, you can pay people a premium if they have to travel as part of their job, or if you recruited them because of some level of education, training, or experience that you believe is related to the job. For example, schools pay teachers more money if they achieve a master's degree over a bachelor's degree. All of those are still appropriate. What's really important for business leaders is that any wage differential has to be for one of these 6 things. That is the entire differential in wage. So if you're paying someone more because they're your brother-in-law, and family is always important, especially for we Italians, is that may not be a sufficient basis for paying someone a differential in wage. because at the very bottom of this slide, what is important about Colorado's law is, unlike the federal equal pay protections, there is no uh, loophole which allows for people to pay wage differentials based on any factor other than gender. The fact that we're related to each other, the fact that I knew you in a previous life, whatever it might be. So it's important that you already start to understand that there is going to be enhanced scrutiny to how people are compensated, which goes to a couple of big rules. One, you can no longer seek an applicant or employee's wage rate history in terms of determining their wage. So you can't ask anyone what their salary history has been in prior employment as they come to your place of employment. That is to try to repair age-old concerns about gender discrimination, the fact that women may have been paid less in the past in prior jobs, and that wage rate differential might be perpetuated if you continue to ask prior salary history, and of course, target that prior salary history as their current compensation. So you can't ask about what people made in the past. You can certainly still ask, because I get this question a lot, what are somebody's expectations about compensation? What would you like to make in this job? That is an acceptable question. You can't simply ask them what they made in a prior job. And of course, the other rule here is you simply cannot come down on applicants or employees for discussing wages or their wage rate in the workplace, or even requiring them to sign a document in which they will not discuss their wage rate with others. That's important for these rules. But wait, there's more. This is a wide-ranging law, and this is one I'm sure you've already heard about. In Colorado, as of January 1st, there are two more transparency rules. This is unlike any other state's equal pay law, and they're important for employers to consider. That's why I spent a lot of time on this law compared to the other laws that we're going to talk about. The first one is an employer has to make reasonable efforts to announce or post all opportunities for promotion to all current employees on the same day, and to make and prior to making that promotion decision. In addition, an even more broad sense of transparency, and one that employers have raised some concerns to me about, are that you also have to post each job opening and the compensation for that job and a description of all the benefits associated with that job in your organization. This is an expectation of all employers. And obviously, we're only a few months into this law, so employers are still ramping up. But this requirement covers all Colorado employers. And it's important that you consider having a policy in which you're going to divulge promotional opportunities and job openings to your workforce. That gets me to the next thing. What does that posting requirement look like? I decided to give a description right here. When I talk about hourly or salary compensation, you can use ranges, but the range is to extend from the lowest to the highest. People often ask me, can I go from lowest to the median? And there's no provision that allows for that under Colorado law. So it's lowest to the highest, or the wage rate for the position. Also, you have to give a description of all the employment benefits that you're offering. Includes, we'll talk about this, sick time, vacation, health benefits, retirement, all have to be made part of this notification for all people to understand what jobs are open. You can imagine this is going to cause some considerations for employers, because now, since everyone's posting their positions and what the wages are for those positions, you're going to start to see employees potentially look to your competitors to see what people pay for certain jobs. And it's going to cause a little bit more competitive environment in terms of what people can receive for like jobs in the open marketplace. So be aware, everyone should be doing this in terms of posting these openings and what they pay. A couple things for posting requirements. I'm not going to read this slide in detail, but it really is, people ask me constantly, what do you mean by promotion, Chuck? What do I have to post to my employees? Well, the definition is anything that would be a vacancy that could be viewed by an employee as being a promotional opportunity. So you have to lean in a bit, and that includes potentially step progressions. Now, if going into the job, you knew that after 6 months you would go from welder 1 to welder 2, and that was made clear that that was going to be an expectation of this job, that may not be a quote promotion if someone was made clear there is this progression as part of the job. But if someone is vying for an opportunity for more pay, more duties, more benefits, and it is presently vacant, then you have to make that clear to all employees it's available. So please know it's a very employee favorable rule, which goes to the next one. What do I not have to post? Well, those jobs that potentially you're going to terminate the person who has the job right now, and you don't want to tell everyone that this job is vacant because the person may learn the jig is up, that they're going to lose their job. This is I mentioned this one earlier, an automatic promotion after a trial period. So if after 6 months you go from welder 1 to welder 2, and that was an automatic promotion after that trial period, you don't have to post that. Temporary interim employees, and of course, jobs that are maintained outside of Colorado. Couple things to think about. And again, I went relatively quickly through this. I'm happy to answer any questions at the end of this program, but I want to be clear. This is a hot topic. This is an extraordinarily administratively burdensome law, as you can tell from this quick discussion about this. And I think lawyers have figured it out that there is room to challenge how people are compensated as they start to discover these wage disparities. You also have to keep job descriptions and wage history for all your employees for up to 2 years. Please know that even if you haven't gotten ramped up completely or you're in the process of meeting this expectation, you should be keeping your job descriptions and wage history. This is likely to defend yourself over the course of the prior 2 years. There's wide-ranging ways to enforce this law. And I will share with you, there is a mini safe harbor from some of the damages associated with this law if employers obtain a pay audit with the goal of identifying any wage disparities within 2 years prior to any action. Doesn't mean you have to get this immediately, but there's a 2-year window. So down the road, if you consider or have learned or think there may be some wage inequity, you should consider potentially obtaining a pay audit, and it certainly might avoid the liquidated damages, often referred to as double damages. That's the penalty for violating this law in the future. So room for thought. What should you do? I strongly recommend, and of course, there's much of this information is readily available. I think you should consider having a policy which discusses your responsibility to meet this law's expectations. I think you should also, in that policy, identify that you will make reasonable efforts to notify employees of promotional opportunities and that you will post job openings as available. I think you also have to train your managers, no longer ask for compensation history, and do not come down on employees for raising interest in whether they're being paid appropriately or their pay level is competitive with other organizations. Next one. That was a lot. And you can tell how this day is going to go because there's a lot for us to talk about. In addition, for Colorado employers, as of January 1st, again, this is the product of last year's active legislative session, Colorado passed the Healthy Families and Workplaces Act. This was a wide-ranging paid sick leave law. There were 3 leaves associated with this law. One has already expired, so I'm going to choose not to talk about it. The emergency paid sick leave for last year expired on December 30th, but there are 2 remaining which are in play for 2021 and beyond. The first one is paid sick leave, and the second one is emergency paid leave. So let's talk briefly about paid sick leave. I pause for a moment here because we have wide-ranging employers in this program. As of January 1st of 2021, if you have 16 or more employees, you're subject to this law. For those of you listening right now, if you have under 16 employees, then you are subject to this law commencing next year. So smaller employers listening right now, you have 1 year to contemplate your requirements under this law. For those of you, and there's a number of you, since I know a number of the employers that are reviewing this program, a lot of you have more than 16 employees. As of January 1st, you should be accumulating paid sick leave for all your employees. And how is that accumulated? 1 hour of paid sick leave for every 30 hours worked up to, you'll hear, 6 days or 48 hours of leave per year. You can always be more generous, and many of you are, and can always accrue at a greater rate, and many of you do. What's important about this law is employees who work for you start receiving this immediately and therefore can use it immediately, even if you previously had some type of waiting period to utilize your time off benefits. Employees can use what they earn immediately, and they can carry forward to the next year any unused amount up to that 48 hours in subsequent calendar years. This is a big deal. And of course, it anticipates COVID, the pandemic, and other health related concerns. What are the reasons an employee may come to you and take time off? Obviously, sick leave for mental or physical illness, not only for themselves, but also for the care of their family members. This is also referred to as safe leave, making employees and their family members safe. If an employee or a family member has been a victim of domestic abuse, sexual assault, harassment, and needs to absent themselves from work in order to make their home secure, get legal advice, get medical advice or care, relocate to flee an aggressor, they would be able to utilize these 6 days for themselves and their family members. And of course, finally, is the pandemic related closure of an employee's business, place of care due to a public health emergency. Be mindful, we're still in a public health emergency. Last December, Governor Polis renewed the original COVID public health emergency, and it continues to this day into the future to some date which will be determined in the future. What do you get out of this benefit? People ask me all the time. I can't read every one of these in great detail, but I would love for you to take these slides. I would love for you to review these slides because there is a treasure trove of information here. For example, I have exempt employees. They're exempt from overtime. They're paid a salary. We don't track their hours worked. How do we track what they get for paid sick leave? Well, they're presumed to work 40 hours a week, and therefore you accumulate paid sick leave as if they work 40 hours a week. Family members is defined broadly, including in loco parentis relationships. People who serve in the place of parents may be potentially able to take sick leave for their, quote, family members in this regard. There is a difficult provision here for employers. Many employers under current sick leave policies, they require employees to provide proof, reasonable documentation, often from a medical provider, to show proof of the need for sick time off. Under Colorado's new law, you can only require reasonable documentation for a leave which lasts 4 or more consecutive days. So if someone says to you they're missing a day here, a day there for underlying health reasons, there's no provision under Colorado law for obtaining medical information to support that use of sick time. So employers are going to have to back off a bit on their pre-existing policies in which they held employees to very rigid standards of proof of the use of sick leave. Of course, if someone leaves, you don't have to pay it unless they return. So if someone quits or is fired, much like current sick leave in Colorado, you don't have to pay that out. And you can't make an employee find a replacement or coverage for their absence, which is self-evident. There's more though. And this is one that has caused, of course, an issue right now. As of January 1st, and this is important, remember we talked about the 16 employee distinction? As of January 1st, there's another leave in Colorado. In the event of a public health emergency, remember I noted this, our public health emergency due to the pandemic was redeclared last December. All employers, mind you, all employers in Colorado must supplement an employee's paid sick leave with up to 80 hours one-time emergency leave. So if you do not have sick leave or you do not currently accrue sick leave, you still have to allow employee this 80 hours of paid time. It's a proportional amount. What does a part-time employee work in 2 weeks or 80 hours for part-time employees? And you can offset existing paid sick leaves against that 80 hours. But if you have an employee right now, an employee who needs time off, we were talking about this last week, an employee who needs time off because they obtained the vaccine and then they've had side effects, or they currently have a family member that is ill and they want to attend to them, or they have a school closure or a hybrid school experience for a child, they may utilize this 80 hours. but it's 80 hours one time during the present emergency. Again, employees don't have to supply you documentation to take this leave. So it is in many cases a leap of faith for employers to have to um, provide this benefit to employees. Employees certainly have to give you notice of the need to take this leave, but they do not have to supply documentation to support that leave. What am I talking about for public health emergency leave? Let's say they are quarantining themselves because of exposure or experiencing symptoms. A public health official determines it's unsafe for the employee to come back to work due to a public health emergency, or the employer decides we can't ramp up yet because of the spike in COVID cases. Obviously, if a child care facility or school is closed, I mean, many of these facilities are ramping back up, but it is a likelihood that it could recur and there could be school closures because of children potentially testing positive for COVID. And then finally, if an employee has a pre-existing condition that they believe due to an underlying medical condition that exposure would cause them more harm, then they may utilize this 2 weeks of leave. Please know that you are going to get employees, all of you potentially, who claim they are unable to work during the present public health emergency, and you should be responsive to that. Couple rules here. Obviously, again, have to maintain records of leave for the past 2 years. Interestingly enough, employers who already provide comparable leave, this is important. So please do not be unduly alarmed. If you already have paid sick leave in place, you can utilize your current policy guidance as long as you follow the same rules. What do I mean by that? The same rules as Colorado law. Well, we provide paid sick leave and we provide a more generous paid sick leave, not 6 days, but we provide 2 weeks to employees, which meets the 80 hours of the public health emergency leave. But the issue is, please recall, you have to allow time off under your guidance for the same reasons Colorado law does. Remember that safe leave? Someone claims that they are in the fight of their life because they've encountered a domestic abuser. Even if your sick leave guidance doesn't currently cover that, you are going to have to allow time off for that leave. It's important that people recognize that fact. I already get a question. Are you finding that companies are decreasing other benefits such as vacation to accommodate these new laws? That's an awesome question. Again, we're only a few months into this, so I really appreciate the question coming my way. Are companies decreasing other benefits? And I have not seen that. And of course, I keep my finger on the pulse of dozens of employers, but I haven't seen a decrease in benefits to compensate for these new laws as yet. That may be a down the road issue for some, but not presently. Let's keep on going. And you're doing well, I hope. I want to make sure I expose you to these rules. They may be brand new to some of you, so I'm going to make sure that we at least give you a sense of some of your obligations in terms of this. There's another new law out there. And again, this law went into effect January 1st. And that is, this law went into effect last year. Please forgive me. But we now have a public health emergency whistleblower law. And of course, is a product of COVID and safety concerns raised by employees. Now, employees are protected from any retaliation, reprisal, discrimination if they raised a safety concern in a public health emergency. And obviously, the statute gives a number of examples. For instance, insufficient personal protective equipment, the desire to bring your own personal protective equipment to work, the concern that we're not following CDC advised safety protocols, all of those provide protections. And of course, this law covers, and they use an interesting term, any principals in Colorado. This is a unique expression, not only any employer in Colorado, that's of course all of you listening, but those people who are general contractors of 5 independent contractors in Colorado and any local or county government. So the city of Arvada, which Daniel referenced in the beginning of this session, is certainly covered by this law as well. You have to give notice to your employees. and it's important to understand that. I'm going to make sure I keep on hitting the questions as I go. I hope you don't mind. And I get a comment. We made the COVID vaccine mandatory. If an employee opts out by choice, we made the policy they have to use vacation time, not sick leave, for any COVID-related absence. I'm thinking now we can't do that. Yeah, I appreciate the question, to me. If any employee potentially opts out of work because of the concern about COVID, they are concerned about the safety of the workplace. You saw that broad provision of the public health emergency leave law that I think you should clearly consider extending those 80 hours, including any paid sick leave, as part of that for the employee's time off. After you exhaust those benefits, then I believe you can require employees to use their vacation. We talked about the pros and cons of mandating the vaccine. Obviously, since I know this employer to some degree, if you're a health related employer, I think you might be in better stead mandating that vaccine. But I would consider offering that public health emergency leave for those employees who claim they're unable to work due to safety concerns during this time period. Let's keep on going. And thank you for the questions. I really appreciate them. I think there's no such thing as a bad question in this area. Got that. Oh, I should also add, all of the laws that we've talked about, the Equal Pay for Equal Work Act, the Colorado paid sick leave provisions, the Colorado public health emergency leave, and now this public health emergency whistleblower law, all of them require you as an employer to provide notice to your employees that they are protected and have rights under these respective laws. I wanted to mention that because I failed to put in the slides. If you go to the Colorado Department of Labor and Employment, they have already published a sample notification requirement for these laws. I encourage employers, especially small employers, to do this on their own and obtain those notifications for your employees. If you have a large population of employees who speak a language other than English, you're going to have to make that notification available to them in the language that at least 5% of your workforce speaks, which could easily be, certainly in Colorado, perhaps Spanish. So very favorable provisions to the employee, but please don't forget that notice obligation associated with these laws. Let's keep on going. And again, I'm going relatively quickly, but I hope to leave sufficient time to answer any questions that you may have. So I wanted to add another legislative change that occurred last year that has caught some smaller employers by surprise. And Colorado, in the last legislative session, 2020, they passed the Colorado Secure Savings Program. This is one that has been interesting for employers. And there's a little bit of good news and bad news here in terms of, well, I think it's in many respects good news. But if you will, the news that surprises smaller employers is that Colorado employers with 5 or more employees who have no retirement plan are going to be covered by this particular law. And so many, many, many employers obviously have made provision for their employees with retirement plans available to them. But if you're in one of those categories of smaller employer with no retirement plan, your employees, much to the surprise of your employees and perhaps the employer, are going to be automatically enrolled in a retirement savings program, which will start in the near-term future, where they're still working on the effective date, they're still working on implementation rules. But your employees, if you do not have a current retirement savings program, are going to have automatic deductions made from their pay, which you will have to facilitate, into an IRA, and that account will follow that employee even if they leave you and go to another workplace. Interestingly enough, the employee can opt out. They can adjust their withholdings. So that's important. They will be notified of this. What is the good news here, if you will, administratively for employers, is an employer isn't required to provide any matching contributions. Many of you do that already. There is very little administrative burden, we're told, because this will be managed at the state level, not at the employer level. And let me make sure after I talk about this, let me go back and make sure I answer some of these questions. I love it. We offer this after 1 year of employment. Do we need to do this effective date of hire? Again, please forgive me on your question. Don't know if you're talking about the sick time or the retirement benefit. If you offer that retirement benefit already, then you're not necessarily required, but I have to share with you, don't know the implementation rules for that. Let's call it a gap year from the date of hire to that 1 year that an employee can potentially participate in your retirement plan. I'm getting another question because I'm going to come back to these, and I love the questions, and I'm going to try to read them out to everyone. Can you count currently in place paid time off, vacation benefits toward the sick leave requirement? Prior to COVID, our part-time employees receive a generous amount of PTO, but a minimum amount of sick leave. Yeah, that's an awesome question as well. The current paid sick leave and public health emergency leave laws allow you to count paid time off. Remember, paid time off is offered by many employers. It's an amalgamation of both sick leave and vacation. In fact, many employers do not require employees to disclose the underlying reason for obtaining paid time off. Colorado's new law does say that you can count paid time off benefits towards these sick leave requirements. But keep in mind, I know the person asking this question, who's very clever, is you still have to follow the paid sick leave rules in counting that paid time off towards this law. Meaning that if you have PTO and you have a generous amount of PTO, employees could use it towards a public health emergency. Employees could use it for sick or safe time off under these rules. But you are allowed to count PTO towards these benefits. It's an excellent question, and I appreciate it. Let me go back to this retirement savings plan, and why I want to mention this to you is, please, because these sessions are so limited, please keep in mind that you're going to start hearing a considerable amount of news about this, and there are fines for non-compliance with this particular law, and they could add up fairly quickly if you have employees and they are not given the opportunity to participate in this retirement savings plan. So we're going to hear a lot more about this. This is one you have to think ahead in terms of what are going to be the obligations. And as I say, while this was passed, and it was passed with relative fanfare, we don't have the implementation rules as yet to give us guidance about what are going to be our requirements in this regard. Oh, excellent. And I'm noticing, thank you for the comment, is there was an excellent CDLE, Colorado Department of Labor and Employment webinar recently. Please check out the chat for the paid leave laws under the Healthy Family Workplaces Act. There are a number of these. You can't watch enough of them because I get a lot of questions that are difficult for employers to answer. Hey, what is the measure of calculation for my part-time employees? How do I figure that out? Does someone get this even though they're a brand new employee? Can they take 80 hours off? And the answer is yes. For the public health emergency leave law. So keep following in the chat. Very helpful for people to do that. Let me make sure I stay ahead of my questions. I'm getting a great question about the Family First Coronavirus Response Act. It says here, I heard that the FFCRA, Family First Coronavirus Response Act, remember that was the federal response to the coronavirus, and emergency sick leave and employer tax credits for its use was extended, renewed through September 30th. Is this accurate? Can we have employees use that type of leave for COVID-related issues for now and then divert to the Colorado emergency sick leave after it's been exhausted? That's a fantastic question, and it's a really great question in the context of Colorado's paid sick leave. So here's the rule now. So the Family First Coronavirus Response Act expired. The leave portion, remember, up to 12 weeks of paid time off under the Family First Coronavirus Response Act, the paid or mandated leave requirement ended on December 31st of 2020. But by virtue of the American Rescue Plan Act, which was passed and signed by the Biden administration, you can still extend Family First Coronavirus Response Act not only for COVID related illnesses, but the law does include now time off to be vaccinated, time off for side effects associated with getting the vaccine. Those are additions to this particular law, but only if voluntarily granted by employers. And you really hit this issue on the head is even though you don't have to give employees time off, if you voluntarily give employees time off, an employer is allowed to receive a tax credit for the amount of paid time they extended an employee for time off related to COVID under the Family First Coronavirus Response Act. In other words, to make this very clear, I have an employee or I have a lot of employees, and I would like to pay them to take time off to be vaccinated and take time off if they're feeling the ill effects of the vaccine. We talked about that last week. You can grant the employees paid time off. You're not required to. You can grant the employees paid time off under the FFCRA, and you then obtain the tax credits through September 30th for giving that paid time off. That's purely voluntary on your part. What goes into the mix, though, is if you don't grant that time off voluntarily, you have to consider this time off as paid under the Colorado Public Health Emergency Leave Law, because that time off, because of the side effects, ill effects, or even COVID-related illnesses, is going to be covered by Colorado law. So there's two laws in play there. The FFCRA is now voluntary, not mandatory. The Colorado Emergency Paid Sick Leave Law is required to be given to your employees who have qualifying time off. Great question. Thank you for allowing me to create the distinction between those laws. It's really important people know that. Let's do a few more things to think about. And I'm loving getting these questions. So I have to make sure I do justice to them. Hold on for 1 second here. Let me keep on going. And again, please keep the questions coming. We have plenty of time to do this. I wanted to talk for those of you that are private sector employers. We talked about this in year or two past, but Colorado has long had a minimum wage order. That minimum wage order was revised 2 years ago to become the Colorado Overtime Minimum Pay Standards Order, or COMPS order. What changed significantly is whereas the prior Colorado minimum wage order only covered 4 discrete industries, they were the service industries, food and beverage, retail establishments, health and medical, and consumer support, customer support operations, window washers to parking lot attendants, those businesses that supported other businesses. Now, most people are well aware, at least if you're a private sector employer, the COMPS order was expanded considerably a year ago to include all private sector employers in Colorado, meaning every employer in Colorado who is a private sector employer is required to follow the COMPS order. Public employers, City of Arvada, by way of example, not covered by this COMPS order. That's important. This minimum wage order does a number of things, and then I'll answer a couple of questions. It does set Colorado's minimum wage, which in 2021 is now $12.32 per hour. Recall in 2020, it was $12 per hour, so it was increased. So please be aware of that for all your employees. And it raised the threshold for tipped employees. Remember, they get to augment their income, their salary, their pay with tipped income. Has been raised to $9.30 an hour. What's really important here is please keep in mind the minimum salary for exempt employees for private sector employees in Colorado was increased to $778.85 per week. Under federal law, the minimum wage for exempt employees is only $35,000 and some change. So in Colorado, exempt employees must be paid a higher threshold to maintain the exemption in Colorado, or you may owe them overtime. And of course, you're probably aware, one of the benefits of doing these programs or any other of these programs is that you will hear from year to year the increase in that salary level for exempt employees up to 2024, in which it goes up to $55,000 per year and then will be adjusted. Also recall, this is the wage order that does require meal periods in Colorado. If a shift exceeds 5 hours, 10-minute paid rest periods, preferably one in the middle of each 4 hours of work. So for an 8-hour employee, they obtain two 10-minute rest periods under Colorado law, and the requirement to pay for distinctive or special uniforms is embedded within this law. Important that you understand that. Again, that has been a recent change that has caught some employers by surprise. Let me hit back some of these questions. I love them. Would you be willing to share the slides? Yeah, and thank you. Before I move ahead, yeah, please. We're going to record the session. It is being recorded. All of these slides are available to you. I do make the slides available to the Arvada Chamber and the Arvada Economic Development Association. That's important that people know that. Another question coming my way: are the 80 hours of public health emergency leave over and above, separate from what the company may already provide as PTO and required 48 hours? It's a great question. Again, I alluded to this a little bit earlier, is that these are requirements under Colorado law, the 80 hours and up to 48 hours of sick leave. An employer can provide more than that or be more generous than that, but you have to, if you're going to be more generous, you have to allow for the same reasons for time off and the same considerations for obtaining this time off for employees, so you can be more generous. Please remember that. In fact, I'm encouraging that, quite frankly. I'm encouraging time off for COVID-related time off. The excellent question earlier about the FFCRA, I happen to be one of those persons who encourages employers to extend paid leave to employees for COVID-related reasons and take advantage of the tax credits associated with extending that paid leave benefit for people to get vaccinated, to incent them to get vaccinated, and potentially to cover them if they have some adverse side effects, which I indicated I've been vaccinated, did not have distinctive or significant side effects, but other people have had a different experience with obtaining the vaccine. So it's a great comment. Please consider that, being more generous, but you have to make sure you provide for the same time off benefits. Let me talk about the last provision here, answer more of your questions, and then we can end. I wanted to mention this, and I really appreciate the chance to talk to you. What's going to be a thorny issue for employers, and that is a thorny issue for all employers potentially in the coming years, is this is something we need to talk about now, because we're already in the period in which we should be considering what will be our organization's position and plan for Colorado's new Paid Family and Medical Leave Insurance Act. This is an unemployment-like system which requires the deductions from employees' wages in order to fund paid family and medical leave. Those premium deductions will start on January 1st of 2023. So we're looking at a little bit less than 2 years in which you will be in the pool of potential employers who are providing this benefit to employees. This paid family medical leave is much like the federal family and medical leave. Remember, it is currently unpaid under federal law, but now employees can utilize. And of course, what's really important about this, presently, the Federal Family and Medical Leave Act only covers employers with 50 or more employees and all public sector employers. This law, and I should extend forward a bit, this law is going to cover businesses with 10 or more employees, and that's important. If you have 10 or more employees, employers with 10 or fewer, with 9 or fewer employees are exempt from paid family medical leave. So if you're a relatively small employer listening right now, this may not be your concern, but for many of you listening right now, if you have 10 or more employees, you are going to be considering complying with this law or making your own policy guidance which meets these parameters. You'll note local governments like the city of Arvada, businesses that already provide paid family medical leave benefits. That's why I love the question earlier. Someone asked me, do you see employers decreasing benefits as a result of these new legislative provisions? My response is I haven't seen it because many employers are already leaning into this particular protection, which may mean if we've never offered 12 weeks of paid family leave, we may have to consider likely doing so in the future. Talk a couple things about this. What's really important about it is it's going to be your employees that work at least 180 days and learned at least $2,500 in wages. The Colorado paid family medical leave is going to run concurrently with the FMLA. So going back to those questions you all asked, which were fantastic, about, hey, we already provide more generous leave benefits. Well, if you're doing that already, this is one you have to put on your horizon in terms of, do I need to offer this to my employees? And that includes that safe leave for victims of domestic violence. You'll note Colorado's paid family medical leave includes a more generous benefit for pregnancy or childbirth complications, up to 16 weeks in that case. So there is a more generous benefit associated with adopting or having children. And that's important that people are aware of that. And then finally, I decided to give you a little bit of a look at these benefit deductions, the relatively complex formula. I decided to give you as much information right now so you could take a look at it. But what I really wanted to leave you with is this highlighted portion of this presentation, is that would you please consider, I know I've thrown so much information on your plate in a very short amount of time, but a thing to do after this session is over is consider organizationally and take a look. And this is where I have to share with you. This is where the Chamber and the Arvada Economic Development Association can start to provide you some consensus information of what other businesses are considering doing in response to this over the course of the next couple of years. As we have this window or opportunity to look at this, we can get some guidance from our resources to try to consider what are going to be some mechanisms to provide paid family and medical leave to our employees if we employ 10 or more employees in the state of Colorado. That, I believe, gets me to 5 minutes remaining in our program to answer any questions that people have. I'm going to ensure that I go back and take a look at these. I tried to tackle as many as I had during the program, but if you have any more, please consider asking them. I'll actually leave it right there for actually either Ryan, who's administering this program, or Daniel or Cami or Sam, who are assisting with this program, to make any comments they have, and to certainly solicit your questions that you may have in terms of any of the laws that we talked about. And we will make the slides available to you so you can review them later on. Let me get one chat question that I have here and take a look at it. You mentioned that we need to keep 2 years of pay history. Is this information kept by payroll processor enough? Yeah, if you use a third-party payroll processing system, there appears to be no impediment to continuing to do that. Obviously, you're going to want to audit your own payroll processor, payroll system if you use a third party for payroll processing. They are likely well aware of this, but not only, keep in mind, not only do you have to consider keeping that payroll information, but also you have to consider keeping those job descriptions, and that may not currently be resident with your third-party payroll processing system. So there's a little bit more, record-keeping responsibility than just payroll records. So it's important that people know that. All right, thank you. Any other questions? And certainly I'll defer to Ryan, Cami, Daniel, Sam, if they have any comments as well.
Awesome job. I don't see any more questions coming in, but you did an amazing job answering all those questions throughout and baking them into your presentation. So big round of applause. I still keep requesting this feature from Zoom to be able to offer a real round of applause to our speakers, because you did an extraordinary job and we are grateful for your time today. As a follow-up to this presentation, as you've heard a few times, we will circulate the recording as well as the slides to follow. We also wanted to take a moment to drop in the chat for you a few resources that might be helpful for you as you navigate a number of these changes that are happening. The first being, we do have a bill tracker on the arvadachamber.org, which you'll find here on your screen, and we'll drop in the chat, that is monitoring this current legislative session, which we're expecting to run through May 31st, and then a special session later in the summer. So we'll continue to monitor business issues, but that's a great place to check in and see how we're tracking those issues and what our feedback as the business community is. We also are including the Arvada Resiliency Task Force COVID-19 resources. We're continuing to update funding solutions, policy changes there, so you have access to that, as well as those consistently changing public health orders. And then finally, the Arvada Economic Development Business Toolkit is also being dropped in the chat for you. Another really incredible resource as you're navigating all the challenges that come along with running your business. So thank you all for joining us today. Another big thank you to Chuck for your time and talent and energy around these really complicated issues. We're incredibly grateful. Hope everyone has a great day, and stay tuned for more webinars as we continue to navigate business challenges.